right movie be our kwaba e de ba Kwame Gentle TV Plus. Mr. No first time I share. No subscribe, no like it. We are no share a views now the comments and so to comment section ho e de amaye. Adofo e sense ma e koso e wo wiase mu e koso e wo media so ene aboabo bi ano aye pese e de be som fi se dane da mo ane ne mo chensem no ene me pesem kasa be tintinti no mo mienko yenkuti.
An originating process should be done differently other than order 4. It's applicable. And my Lord, if you look at the reasoning of the trial judge, yes, he did not reason that the application was brought pursuant to order 4, for which reason he was not going to hear it.
Having said that,
so I'm just pointing out.
I was asking whether, given that order 55 has prescribed the means by which the court may hear a party whose interest will be affected, there is a need to even call in order 4, and whether order 4 has legal basis.
My Lord, a quick
in a judicial review application.
My Lord, we notice that the issue of natural justice,
yes,
is a constitutional matter.
Yes,
and the rule cannot, as it were, defeat the intent of the Constitution. That to the extent that a person will be affected by a judicial decision, that person ought to be heard, yes, with or without the rule. And so the issue of the rule coming in aid with the greatest respect does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. 2.
Yes, proceed.
In addition, my Lord, even without order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
In what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition,
yes,
and then the statement of case in opposition.
Very well.
Address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review application. Judicial review application. My Lords, exhibit attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondent, National Democratic Congress. My Lord, is in the supplement. Yes, so my Lord, I'll be very specific. I have a supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other guys have it as A or C. Is the problem you have created for us?
My Lord, I'm sorry. I'm sorry about that. My Lord, that should be exhibit D in our supplement. Is the application for judicial review by the NDC.
Yes, you make the point, and let's see if it will help us locate the exhibit.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. But no, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Okay.
Was it pending in that court or it was right before him?
No, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. But my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes,
You see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. Okay. The process he found.
You can read.
No, just hold on.
Please. What he found was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, brothers. He came to court holding the documents.
No, we're talking about the second application. Or the what we call the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
yes.
Continue.
So, my Lord, at the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared considering the mandamus, he knew that that would definitely affect their rights. My Lord, on the grounds on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. My Lord, 2, the mandamus application, in one breath, my Lord says our gender on page 2, offense under Rule 14 of CI 47. However, my lords, the mandamus application